Awesome. Thank you, Michelle, for joining us for this webinar. If you guys do have questions throughout, please feel free to put it in the chat box and we will answer them. And then at the end, we will have a quick little evaluation for you all to fill out. So with that, Michelle, the floor is yours.
Thanks, Taylor. I see that Tracy posted that the chat box is disabled. She posted that in the Q&A, so I don't know if there's a way we can
Fix that.
Thank you, Tracy.
Okay.
Well, while Taylor's doing that, I'm pleased to be here talking to you about special needs trusts and government benefits for individuals living with disabilities. Prior to joining Northern Trust, I worked as a partner at a law firm in Minnesota, practicing in Minnesota and Wisconsin, and special needs planning was a large part of my practice. I currently work at Northern Trust now as a senior trust advisor, and in doing so, I still work with special needs planning and trust administration. Please know that I cannot give legal advice, and this presentation and what I say is not intended to be construed or interpreted as legal advice. But I do have attorneys that I know that I can provide names if needed. Again, please put your questions in the chat box and feel free to do that as we go along. Taylor will read them to me, and hopefully maybe we'll have some time at the end as well for questions and answers. I'm going to share my screen now. Oh, Taylor, my screen sharing is disabled. Would you mind enabling that for me?
You should be set now.
All right, there we go. Okay. So today we are going to talk about 4 topics: special needs trusts, pooled trusts, qualified income trusts, and of course, government-sponsored benefits and entitlements. Special needs trusts are trusts that are designed to allow an individual living with a disability the means to have extra funds available to them without affecting their eligibility or amount of certain government means tested benefits. And by means tested, it just means that qualification and eligibility is based on an individual's income and or assets, usually both. We're seeing an increased use of special needs trusts because we're seeing an increase in the number of individuals living with some type of disability. According to the CDC, 1 in 4 individuals is living with a disability. At this time, the estimate is that that's only going to increase. There's 2 types of special needs trusts, and in some states you might hear these referred to as supplemental needs trusts as well, but for the purposes of this discussion, I'm just going to refer to them as special needs trusts. A first-party special needs trust is funded with the assets of the disabled individual, and it could be either assets that were awarded through damages in a lawsuit. It could be an inheritance received. It might be that the individual suffers a disabling condition later in life and has assets of their own that they want to protect in order to qualify for certain means tested government benefits. With first party special needs trust, the Treasury regulations require that there be included a provision which says that upon the beneficiary's death, before any other payments or distributions can be made, that the amount of Medicaid benefits paid on behalf of that individual must be repaid to the state. If there happens to be assets remaining in the trust after the full amount of Medicaid benefits have been repaid, then those assets can be distributed to individuals or entities named in the trust document. The one thing about special needs trusts is that they must be established prior to the individual attaining age 65. If somebody reaches age 65 and thereafter becomes disabled, you're going to have to look at other avenues to see how you can protect assets, have them available to supplement the individual's quality of life and still maintain those government benefits. Conversely, a third-party special needs trust is funded with assets of someone other than the disabled individual or their spouse. Could be a grandparent, parent, sibling. Those are the ones that we see most frequently creating these types of trusts. The nice thing about these trusts is that there's no requirement that the state be paid back for Medicaid benefits paid on behalf of the individual beneficiary. And accordingly, family members or other entities can receive assets remaining in the trust after the death of the beneficiary who is living with a disability. It's important that you have somebody who is familiar with special needs trust and planning draft these documents for you. It's fraught with many traps for the unwary. There are a lot of rules set forth in the Social Security Administration's program operations manual system around what's allowable and what's not, around eligibility requirements, income and assets. And it's very important that somebody who's familiar with this both establish the trust and administer it. These trusts have to have wholly discretionary language, both with regard to when distributions can be made and the amounts of the distributions. Importantly, the beneficiary cannot have any control over the trust. They shouldn't have withdrawal rights. They shouldn't have ability to be a co-trustee. They should have no involvement whatsoever other than simply being a beneficiary of the trust. Importantly, distributions for food and shelter must be prohibited. In that regard, a typical standard that you might often see in trusts of health, education, maintenance, and support is not appropriate for a special needs trust. Including that information is going to turn it into a support trust. And when the beneficiary's eligibility for things like supplemental security income, SSI, or Medicaid benefits is being made, they're going to consider the assets available to the beneficiary, and that's going to put them over the asset eligibility limit. Importantly, the assets should supplement government-sponsored benefits, not supplant them, which is why we want to prohibit distributions for food and shelter. You may have previously heard that clothing can also, distributions for clothing can also not be made, but that was removed. And now the trust can pay for clothing for the beneficiary. As I mentioned, a trustee needs to be knowledgeable about the beneficiary's condition and eligibility for certain governments and certain governments benefits and the complexity and rules regarding those. So in some cases, a corporate trustee is appropriate, and sometimes a corporate trustee along with a guardian or family member who understands the beneficiary's condition and can advise on that might be appropriate. It's really important because failure to understand the prohibitions and the rules could result in a beneficiary's income, a supplemental security income benefit being reduced and or losing eligibility for the benefit altogether. The supplemental security income eligibility in many states is tied to Medicaid eligibility. So if there's an inadvertent disqualification and determination of ineligibility made, it could result in the health benefit also going away. In addition, distributions from a special needs trust must be made carefully. You can directly purchase items for the beneficiary, directly pay third-party vendors, and you can pay credit card balances on statements, but you really need to review those statements because if there are any charges by the beneficiary for what could be considered food or shelter, maybe they went to McDonald's and Olive Garden and then rented a hotel room for one night. Those are considered food and shelter, and distributions from the trust to pay for that food and shelter is going to result in a reduction of benefits in 1 or 2 months following that payment. That's one thing to note is that the supplemental security income benefit income and assets are reviewed regularly. And so making these distributions, you're going to see the consequence of doing so rather soon. And that can create a significant hardship for the beneficiary if he or she is relying on those benefits to help pay, rent and grocery costs. For this reason, also because we have to watch the income and the assets that a beneficiary has to maintain their eligibility, the trustee should never distribute funds directly to the beneficiary or reimburse the beneficiary for purchases. And along with that, the beneficiary should never be provided with gift cards. These are treated the same as cash and our income to the beneficiary for purposes of SSI and Medicaid qualification. And similarly, the that program's operations manual system, the POMS manual, also says that if the beneficiary gives something, or excuse me, the trustee gives something to the beneficiary which can be readily converted into cash, that also counts as income. I don't know how in practice that is treated, because technically if you're buying clothes for a beneficiary, you're buying them movie tickets to go see, you know, the latest movie, anything can really be converted into cash. So I'm not sure in practice how that operates, but it's something that is in the manual. Taylor, do we have any questions yet?
Not right now.
Okay, then I'll move forward. This is a non-exhaustive list of examples of distributions that are allowable from a special needs trust. And a trustee, when making determinations of distributions or purchases with money in the trust, should really think of it through the lens of what is supplementing the beneficiary's quality of life. Again, not supplanting the food and shelter benefits that are provided through SSI and Medicaid, but enhancing the quality of life. So you see here some examples of vehicle, accounting, legal, and other professional services. Furniture, appliances, and household goods can be purchased. Caregiving and companion services, which is a definite help in a lot of cases, especially family members who are the normal caregivers need to still work and hire somebody to come and give care in the interim. Pay for a cell phone, club membership dues, education-related expenses like tuition and books, or I guess maybe we don't buy books so much anymore, it's all online, laptops and such. Entertainment, the movie tickets, the performances, concerts, going to the theater. But be careful if you buy the popcorn, technically it's supposed to be reported out as a food expense. The trust can also pay for medical and dental expenses that are not covered by Medicaid or insurance. Grooming services, hobby supplies, maybe your beneficiary loves to paint, loves to make crafts, things of that nature. House cleaning services, non-food grocery items and over-the-counter medications, pets and pet supplies. The trust can pay for utility bills if they're not considered a disqualifying payment, meaning they're not considered in-kind support and maintenance, food and shelter payments, which I'll get to in a second. And certainly the trust can pay for vacations and travel for the beneficiary. Whether the trust can also pay for a companion and their expenses related to the vacations or travels, that really is a fact-dependent situation. And it's going to depend on the beneficiary's needs. Do they need that assistance for mobility purposes? Do they need somebody there to ensure their safety? Those are the sorts of factors that are taken into consideration. I mentioned that distributions from a special needs trust cannot be used to replace the shelter benefits that are provided, which are intended to be provided through the supplemental security income payments. There is a list in that POMS manual, and these items are set out here are what are all considered food and shelter payments. And of course, that is any food, meals, groceries, and that includes dining out. Mortgage and rent payments should not be made. That is considered to supplant government benefits. Property insurance payments should not be made if there's a mortgage on the property and insurance is required by the mortgage, which I've never seen a mortgage that doesn't require insurance. Should not pay for real estate taxes or utilities like heating, fuel, gas, electricity, water, sewer, and trash removal is also considered a shelter expense. So again, making one of these distributions is going to reduce the beneficiary's SSI benefit in a subsequent month. I will say though that the reduction of benefit is not based on a dollar for dollar. So let's say the mortgage payment was $1,000, and that's more than the maximum federal benefit amount, which I think this year is, well, I don't remember what is in 2023, but let's just say it's $750. Instead, if the trust pays for any of these items, the supplemental security income payment amount is going to be reduced by what is referred to as the 1/3 value rule, or the presumed maximum value rule. And there's not too much difference. The 1/3 value reduction rule applies when the individual lives in another person's household and receives food and shelter from that household. Basically what this does is take that maximum benefit, or whatever the maximum benefit that the beneficiary is entitled to through supplemental security income, if it's less than the maximum, and reduce it by 1/3 of that amount. The presumed maximum value applies in all other situations, and basically that's also a 1/3 reduction of the benefit, plus a $20 income disregard. And that goes back to the qualification for SSI benefits. There's, they take a look at both earned and unearned income, and resultingly there is exclusions from countable income for certain earned and unearned income types. And one of the exclusions for unearned income is $20, and that's where they get that $20 amount from.
Hey, Michelle, we do have a couple questions. I did
Okay.
just send you one over in the chat just because it's a little long for me to read, but if you want to take a look at
So
it.
I can't see the chat when I'm sharing because
Oh,
I
okay.
have
I can go
the
ahead and
screen
read it.
displayed here.
No worries. Okay. It says, how can a client qualify for QMB/Medicaid and not have to pay 20% of bills if they have a trust set up to pay medical bills not paid by Medicare as the primary insurance? The individual said, I have a client like this. They are very willing to pay the 20%, but I cannot collect it because they are a Medicaid QMB client.
Okay, so I guess the little bit more context, if it's not designed as a special needs trust, is that what I'm understanding? That trust that the question refers to?
I'm not sure.
Yeah, okay. So if they're willing, if it's Medicaid, because Medicare is not means tested, so it must be Medicaid benefits. And the trust is, I'm going to assume it's established as a special needs trust. There should be no, is the 20% a premium? This is a little bit different than the typical Medicaid benefit that I'm aware of. So if the 20% is a premium, the trust should be able to pay it, as well as other expenses. So I'm not quite sure what is meant by you can't collect it, but it can be paid by the trust if it's set up as a special needs trust, the health insurance premiums.
They said Medicare pays 80%.
Well, if it's Medicare, then it shouldn't matter, because Medicare is not a means tested benefit. It's just Medicaid that has the income and asset limitation requirement, which is why you set up the special needs trust. I guess without seeing the trust document, it's hard to answer that question as well.
Right.
I'm sorry to be so ambiguous about that, but I don't want to give a specific answer without more of the facts.
There's another follow-up question that says, is it a
Okay.
QMB problem that does not allow clients to pay anything?
I think that is the case. Yeah, I think that is the case. But again, if it's Medicare, it shouldn't be an issue paying from the trust, because it's not going to jeopardize any benefits. Again, I'm sorry that I don't have quite all the facts. to answer that question.
I think
I
that's,
might, okay. Is there,
I-
did you say there was another question?
there's one more question. Is alcohol included under food to make it not allowed?
I would say you should not purchase the alcohol, correct? Anything that the beneficiary consumes, it would be wise to not purchase that. Hopefully they have a little bit of money left over from their SSI benefit that they can purchase.
Thank you. That was the last of the questions at this time.
All right. Pooled trusts, as I have up on the screen here, those are another type of special needs trust, but you don't you don't sign a trust document to create them. They're basically have to be administered by nonprofit organizations. And there are a number of them that are established to provide this trust service. Each beneficiary has a separate account, so it's like fund accounting, but all of the assets are put together for purposes of investment and management. These nonprofit organizations may have different minimum deposit requirements, different fees, and different policies. So if a pooled trust is something you're considering, then you'd want to do your homework and look into what is best for the beneficiary. But these can be funded with assets of a third party person or assets of the individual with a disability. Again, there could be different allowable distributions versus special needs trusts if we're not worrying about qualifying for means tested government benefits like SSI. However, unlike a special needs trust, all or a portion of the funds are either A, retained by the nonprofit organization and then reallocated to all the other beneficiaries after our beneficiary has passed, or they're used to repay Medicaid, or sometimes both. They might repay Medicaid, and then if there's assets still remaining, they're retained by the nonprofit organization. These can be created in Florida if the individual with a disability is over age 65. I don't know if you remember earlier, a first party special needs trust cannot be created for somebody if they're age 65 or older. So this would be one option to be able to have some money set aside to be able to provide the beneficiary with an enhanced quality of life without jeopardizing their means tested benefits. And moving on here, qualified income trusts are Florida specific only. So if your beneficiary does not reside in Florida, this won't apply to them. Not every state has this type of trust available, but I'll go over it briefly since we are in Florida. It can be established by the individual, their spouse or legal representative, or a court, and they are only used if the individual has too much monthly income to qualify for Medicaid or SSI, but they are under the asset limit. And the asset limit, if you have a couple, the asset limit is $3,000. That's the maximum amount of assets they can have, subject to exclusions, of course, but generally that $3,000 applies. An individual, it's $2,000. The idea behind these qualified income trusts is that every month, whatever your excess income is, so you don't go over the income limit, and it varies by year, is transferred to this qualified income trust so that you can maintain the eligibility of your means tested government benefits. The assets in these trusts can only be used to pay nursing home or medical expenses for the individual with a disability during their lifetime. Again, it doesn't help if their asset amounts exceed the limit for Medicaid and so SSI. And Florida does retain a lien on funds in these trusts, again, for repayment of the Medicaid benefits paid on behalf of the individual during their lifetime. Now we're going to move into talking about some of the government-sponsored benefits and entitlements, and I'll let you know if they're means tested or not means tested. So the government does provide different benefits for income replacement benefits, shelter benefits, and food and other assistance benefits. So we're going to start here with income replacement. Again, we've talked about SSI, supplemental security income. This is means tested, meaning its eligibility is based on income and assets. And there are those income and asset exclusions. It's a very it's a long list, I should say, of what's included in countable income and what's not. Certain distributions, as we went over from a special needs trust, can affect the beneficiary's amount of SSI or cause ineligibility altogether. And again, if they are rendered ineligible for the SSI benefit, if they are in a state where eligibility for SSI automatically entitles the individual to Medicaid, then they're going to lose their Medicaid benefit as well. So it could have a very adverse outcome. On the other hand, Social Security Disability Income, SSDI, is not means tested. Eligibility is not tied to asset or income levels, but you do have to have a sufficient work history to qualify for the benefit, just like you would if you're going to get the retirement benefit. Because it's based on that work history, that's why it's not means tested. There is a special type of SSDI benefit called the Adult Disabled Child Benefit. And I've discovered in talking to people that not many are aware of this benefit. Basically, it's available to unmarried adults whose disability was determined before they reached age 22. They collect on the parents' social, work history, which is why it's called a child's benefit. And then the benefit is determined based on the parent's work history, so that the adult disabled child can start to collect when the parent either receives SSDI benefits for themselves or starts receiving the typical Social Security retirement benefit. The child applying for this benefit does not diminish at all what the parent's benefit would be. And a lot of times, if the child has been receiving SSI benefits, and when I say child, I mean, even for 40 years old, they might have their eligibility determined to see if they qualify for the adult disabled child benefit, because a lot of times the monthly benefit can be higher than what they're receiving through SSI. And then as well, they don't have to worry about maintaining their eligibility for SSI benefits any longer, and could be going on the adult child benefit under the parent's SSDI record could result in Medicare eligibility. And now we're on to the Medicaid and Medicare. The Medicaid is run by the states, even though it's substantially funded by the federal government, and the federal government has specific rules and regulations in place, which are also passed down to the states, and each state has their additional rules and regulations, which are usually very similar to the federal ones, because if they go too far off base, they're not going to get that federal money. This is a means tested benefit like SSI, so you do have to qualify based on income and assets. And as I noted, sometimes in certain states, if you qualify and receive SSI benefits, you're automatically entitled to receive Medicaid. Medicare, on the other hand, is run by the federal government, and it is available to those age 65 and older, as we know, and also those under age 65, but who have been receiving SSDI benefits for at least 2 years. And that is how even an adult disabled child could receive Medicare if they qualify and receive benefits, SSDI benefits based on their parents' record for 2 years, then they should get that Medicare eligibility, again, coming off of Medicaid and not needing to be concerned about losing eligibility based on income or asset levels. And then ABLE accounts. This is a hot topic. They can be very popular. ABLE accounts are created and named after the 2014 legislation by the federal government, which allowed states to create their own legislation for ABLE accounts. It's a tax-favored savings account meant to assist individuals living with a disability to pay for extra costs associated with that disability, such as, durable medical equipment, specialty vehicles, certain, foods if the disability relates to something that requires them to have special food. So it actually is a pretty large range of expenses that can be paid with ABLE account monies. In order to be eligible, though, the person must have been deemed disabled prior to their 26th birthday, not means tested, and distributions are not taxed as long as they're used to pay for those qualifying disability-related expenses. And the good news is anyone can contribute to the account, the individual, family members, friends. But the maximum amount that can be contributed in any year is tied to the annual gift tax exclusion amount. So in 2023, the maximum that can be contributed to an ABLE account for a beneficiary is $17,000. And that could come from, anywhere. It's a cumulative limit. Unlike if you were just making gifts to individuals where you could give anyone 17, here the max that can go in is 17,000. Each state has a different cumulative limit for how much money can be in an ABLE account. In Florida, if you open an ABLE account here, I think the cumulative state limit is $480,000. Each states are different. If you're interested in the Florida ABLE plan, it's called ABLE United. I believe the website is just ableunited.com. If you are interested in ABLE plans for other states, there's a great resource called the ABLE National Resource Center. If you Google that, you'll find the link to their website, and you can go and find synopsis of each state's plans, including the cumulative limit, who administers the plan, the requirements, etc. So it really is a helpful resource.
We
The
do,
one important, oh, go ahead.
we do have a question. Is there a trustee or someone that controls the ABLE account?
It's not a trustee, it's whomever is administering the account itself. That institution does. So you would submit claims, like if there was a purchase for durable medical equipment, most of the time you send in your receipt and they can reimburse, or you send in the invoice and they pay directly. If you have somebody who's receiving means-tested government benefits, they should pay directly and not pay or reimburse the beneficiary for anything. That brings me to the other important point here is if somebody is receiving SSI benefits, their eligibility for those benefits is going to be suspended if the account balance plus the individual's other assets exceed $100,000. And that is for every state. That's an SSI and Medicaid rule. It's not in the ABLE rule. So careful monitoring should be given to that account balance if the person is receiving the means-tested government benefits. Any other questions, Taylor?
That is it.
No. Okay. So next we'll move on to housing benefits. There's two types of housing benefits available. The general federal subsidized housing and the Section 8 voucher program. General subsidized housing provides low-income individuals, do not have to be disabled, any low-income individuals with the ability to rent housing at below market cost. The eligibility, though, is based on the family's income, not just the individual living with the disability's income. But special needs trusts and distributions from special needs trusts are usually excluded from calculating the family's income. And there is no asset limit here. It's just eligibility is just based on income. The Section 8 voucher program is administered by local housing authorities, and the low-income individual generally pays a percent of the rent that the landlord is charging, and that percent is based on the individual's income. And the local public housing authority pays the remaining rent to the landlord. So the landlord is getting the full rent charged, but the low-income individual is only paying a percent of that. This doesn't apply to every rental unit. The landlords have to be part of the Section 8 program in order for somebody to live there and pay rent based off of their income. And then other assistance that we have available would be your TAMP, Temporary Assistance for Needy Families, provides childcare assistance, work assistance, and job preparation assistance, It's administered by state governments, and so the eligibility does vary by state, and it's going to be, of course, the state where the beneficiary resides. Available to low-income and unemployed or underemployed individuals, and distributions from a special needs trust could affect the eligibility. It is considered income for qualifying purposes. Something to keep in mind. And then the food assistance program, the SNAP It's federal program providing food benefits to low-income individuals and families. Eligibility is based on the individual's income or the family's income, depending on who makes up the household, and their resources. The good news here is there is a slightly higher resource limit for households in which an individual with a disability resides. That is the extent of my prepared remarks, but I'm happy to answer any more questions that people might have. I'll stop sharing here. There we go. Any other questions, Taylor, that you're seeing?
Not right now. I don't see any.
Okay.
I do have an evaluation form, and there is space for individuals to put any additional questions if they do happen to think of some.
Okay. That's great to know. Yeah, and Taylor can get those to me. And I'm happy to answer them to the best of my ability. So I do appreciate everybody taking the time to attend today. And hopefully you've learned something that is going to be helpful to you and your loved one going forward.
We did get a couple thank yous in the chat, so thank you so much. And if you guys,
You're very welcome.
I did put the evaluation link of the Google form in the chat box. If you guys can just take a few minutes to click on it and fill that out.
Excellent. Thank you, everybody. Have a great evening.
Thank you, Michelle.
Bye-bye.